On. Good evening, everyone. Welcome to week 5 of Principles of Commercial Law. This week, we're talking about our final topic in relation to legal relationships, and that's, of course, the agency relationship, which is a nice one. There's, lots of little nuances and things that we can be thinking about in terms of the way that parties relate to one another, in terms of their responsibilities, potential liabilities, all that sort of stuff. So it's a nice sort of meaty topic, and we save it till the end of this sort of half of the term for that reason. Before we do get underway, I've allocated a little bit of space to cover any questions that anyone has about the assessment. I know that there's, assessments for other subjects swirling around at the moment too, so probably not everyone's had a chance to have a huge look at this, but there is time. If anyone had any initial questions about the assessment that is up on Moodle now, I'm happy to sort of spend a little bit of time going over those and answering those.
Nothing other than I called it.
Well, I can't confirm or deny that. We can talk more about that in a couple of weeks' time. Nat, Josh, no questions? Excellent. So it's due, the assessment is due on next Friday, which is the Friday of sort of the midterm break. So that should give you guys a good chance to spend a bit of time on this while there's no classes going on and things like that. Even though it is a break week, I'm still very much online. So if you guys have questions, anything that you want to quickly clarify over the next week and a day, you're of course more than welcome to shoot me a quick email, and I'll, if it's something that can be answered via email, we'll do it that way. If it's something that needs a bit of a chat, we can organize a Zoom session or something like that. Otherwise, we'll move on to talking about agency. And I think, this has been a common theme over the past few weeks in terms of thinking about ideal starting points for thinking about this topic, and really sort of pinning down the relationship as a good starting point. And the same is true in terms of agency. So, if you're a little bit stuck in terms of thinking about where to start with something, looking at the relationship between particular parties first, and in particular, is there anything that can sort of that would indicate to us that we can characterize this relationship as being between a principal and an agent? It can be a little bit tricky when we sort of, what is principal agent, what's bail or bailee, some things like that. But if your starting point is looking at the relationship between two people and trying to figure out what's going on, you'll at least be clued on that there's a possibility that there's a principal agency agreement or arrangement going on. The next thing that you can do is look to the sort of action or actions that are involved, what's been done, what's been said, what's been agreed, to really sort of keep cluing you into whether there's an agency relationship at play. And then if we think that there is, then a really useful sort of midway step is to think about authority and determining what sort of authority the agent has. So, what's actual or express, what's implied, and what's apparent. And sort of under each of those headings, think about, okay, what are the kinds of things that an agent in this situation might be able to do? And then compare that to, what's actually being done. What are the actions? Do they fit within that authority or not? And then it's a last step, thinking through the consequences. So, what's gone wrong, who's suffered loss, who might be liable for that, all that sort of, quite standard questions, but in particular, thinking about this through the lens of a principal agency relationship is thinking about what are the circumstances under which the agent will be liable and what other circumstances under which the principal will be liable can be a really important question in terms of thinking about those consequences. So even though, by this point in your studies, your mind will probably quite quickly go to thinking about the consequences, taking that little bit extra time to think about, okay, who's actually liable for this particular problem is usually worth it. Any questions about agency? Super. Alrighty, so let's get into our tutorial questions for this evening. And the first one is pretty brief, and it's explain implied authority. What's implied authority compared to sort of some of the other types of authority?
So I guess the easy way to describe it, it's those things that aren't actually written. So they kind of go without saying as part of instructions that you're given. So, and it could be something as simple as, so you might be given an express instruction, but wrapped around that are all the other things that go with that instruction. So it might be sending documents, which don't necessarily form part of that actual instruction that's been given. Yep.
Yeah, absolutely. So the sort of actions that are incidental to carrying out the express instructions is a good way of framing it. Anything else to add for that one?
I just had that to do with business efficacy. So things that pretty much along the same lines as what Nat was saying. Like, so, you know, a manager of a shop would be authorised to purchase stock and that sort of thing. So to do with the actual business efficacy.
Yeah, so sort of thinking about, yeah, you know, you don't want an agent to have to go back and get permission for every tiny little thing that needs to be done. You know, you give them that implied authority, and that helps make things more efficient. Yeah, absolutely. Anything else to add? The other thing, oh, sorry, you go, Nat.
Yeah, I was just going to say maybe another way of putting it is everything that falls within its scope.
Yep.
Usual trade and custom was another one I had. So if it's within its usual trade and custom, then that would be an implied authority.
Yeah. So you know, where there's a pattern of behavior or action, that can be a really important element of implied authority. A related idea would be kind of where there's agents of a particular class or sort of profession, then there's a sort of a set of implied authorities that usually runs with that. So a good example there would be sort of real estate agents, and there's an implied authority to, you know, do actions around, you know, holding open homes, those kinds of things as well. So where there's a particular type of agency that's quite common, the things that are sort of commonly known to go along with that agency will be implied into the relationship as well.
Or is the property manager, based on that, incurring a small cost or a small fee to the agency in order to complete their works? So if a property needs to be mowed before a tenant moves in, the owner has not been able to be contacted, the property manager could incur a cost on behalf of the agency to have that lawn mowed for the tenancy to move in with a tidy yard. That wouldn't be unreasonable.
Yeah. So sort of, just the kind of, little jobs that would need to be done that, sort of, as Tammy was saying, you know, it's efficient to just get in and do it rather than, you know, having to go through a big process. Yeah, absolutely. Can we think of any other examples of
I had
types of things?
Consistent course of past dealings.
Yeah.
So if there's a pattern of past dealings that's been consistent, then there's an implied authority in those circumstances.
Yeah, absolutely. So, you know, past behavior. Yep. Awesome.
What about job title?
Sorry, say that one again.
Job title.
Yes. Yeah. So where someone, you know, holds themselves out as having a particular role, the that can be tricky because it can start to spill over into apparent authority a little bit. But where the action, let's say, fits within the types of things that normally be associated with that role, then yeah, there can be an implied authority for sure.
Husband and wife and partnerships.
Yes, very good. Yep. Fantastic. Any other sort of concrete examples like that? So we've had the property manager, husband and wife. Can we think of, yeah, sort of other more sort of practical or tangible examples?
Business partners.
Yeah. Yep. What about sort of thinking, I suppose, ahead to your potential careers down the track? What sort of implied authority do you think lawyers might have? What are the sorts of things that you might be able to do with implied authority? And what are the sorts of things would you have to sort of go back to the client for further instructions to do? We had before, Nat sort of mentioned sending documents as being something that might be implied in the agency relationship. Are there other things of that nature that we can think of?
Well, I would imagine phone calls to chase up certain other parties, or even to lodge documents within the courts. I mean, I would imagine that would be part of the implied part of that lawyer-client relationship.
Yeah, absolutely. So filing documents and things like that, responding to other parties, and in particular complying with sort of, I'm assuming you guys have done civil procedure, but kind of, complying with the process of discovery and things like that would be, implied in the normal course of duty that a lawyer would do. So, those are just some things to be thinking about as well, if you do go down that path. I think we've probably covered that question pretty well. So let's move on to our next question, which is a hypothetical scenario. Bob, the yacht builder, visits his bank and asks to speak to the manager about a business loan. He's taken to an office and introduced to Janine. During the course of the meeting, Janine says she thinks that the bank's business could be improved if it had a yacht on which to entertain customers, because of course, why wouldn't it be? She signs a contract commissioning the building of a valuable yacht. Bob builds the yacht, and then he finds out that Janine did not have authority to commit to the bank to the contract. What are Bob's options? So as usual, we'll, brainstorm some ideas. We'll think about, the kinds of things that are going on, and then we'll talk about how we might flesh that out into a well-structured, well-refined answer. So what are your initial reactions to this one?
What was Janine's job?
Yep.
That would have to be discussed first, because if she's, let's just say, a bank teller, it's pretty crazy to try and contract with a bank with a standard teller. If she was the managing director of the bank, if it was, say, a building society or something like that, but there's one branch or one major branch, that would be reasonable. But otherwise, you'd want to know who she was, what her role was.
Yep. So finding out a bit more about Janine and her position in the bank. Yep. What else leapt out?
For me, I question, going back to sort of that implied sort of business sort of past dealings, I'd want to know whether or not there'd been other discussions between Bob and Janine. Had there been past dealings, had there been previous discussions about this yacht, knowing that he's a yacht builder. So yeah, to see whether or not that is an implied authority versus obviously apparent. So yeah, I'd want to know a little bit more information about that. And whether or not Janine's role, pretty much along the same line as what Josh was saying, whether or not this is within her custom and trade and usual sort of dealings. Is this something that she does do? Has she commissioned other people to do a similar type of job?
Yep. So finding more about Janine, finding more about the Bob's previous dealings with the bank, most importantly. Yep. Cool. What else?
Well, for me, it was clear that from the facts, that there's no clear authority for her to act. So I did pull that one out.
Yep. So no express authority. Yep. What else?
I was just thinking along the lines of maybe she was delegated authority, but we don't know that.
Yeah. So in finding more out about Janine's job, and what she's done in the past, all that sort of stuff, we might also want to know, is there something, some kind of responsibility that she's given that we could use to argue? We could, we'd look into it. The difficult thing, I think, would be that in the facts, we're kind of told that Janine didn't have the authority to commit the bank to that. So, we might assume that there isn't something like that. But, if that sentence was a little bit more ambiguous, if instead of Bob discovers Janine didn't have authority, it's the bank claims that Janine didn't have authority, where there is a little bit more ambiguity, then we might want to go looking for that sort of stuff. Yep.
There's also that relationship between employer and employee. So there's a lot of question marks around where that authority lies within her role as well, because obviously there would be a lot of implied authority for her to act as an employee. So again, it does come back to Janine's role, but it also stems around that employee relationship.
Yep, absolutely. And sort of related to that, what do we think about the sort of the element of the facts where Bob asks to speak to a manager and he's introduced to Janine? Is that relevant? Can we use that?
So that could be apparent authority then, could it not?
Yeah.
And then we could obviously go into the liabilities when you have that, but I would assume if he's introduced to her as a manager, that would be apparent.
Yep. So in thinking about, obviously we do want more detail about what Janine's job is, and the specifics of that, and whether Bob has had prior dealings with the bank, prior dealings with Janine. That's all going to play a part. But on the pure facts, we sort of, as far as Bob knows, he's asked to speak to a manager. He's been introduced to Janine. It's pretty reasonable to assume that Janine is a manager. And then, in terms of finding out more about the facts, Bob's familiarity with the bank will go into that. If he's in there every week and he knows that Janine is the cleaner, then the reasonableness of that assumption does become pretty problematic. If she's got, a name tag that says, "Hi, I'm Janine, I'm the manager today," or something, then leans the other way. So on the facts, there's a reasonable assumption that Janine has been held out as the manager at least. But we want more detail to, I suppose, confirm that as well. But we'll revisit that in our answer for sure.
Yeah, that goes along the same sort of line as some of the other cases that state, if you've got a rubber stamp that has your name and your actual title, if you've got, your little board in front of your name, in front of your seat on your desk, all of that lends to actually establishing you as acting an agent.
Absolutely. And I mean, and it comes back to these ideas about business efficiency, right? In terms of you don't, every time you want to go into a place of business and deal with someone, you don't want to have to be doing all these background checks to find out that the person is who they say they are, because 99.9% of the time they will be, and it won't be a problem. So being able to rely on this apparent authority is a really important avenue for ease of business, really, as well. Anything else leaping out to us at the moment?
For me, I'm probably jumping a little bit ahead, but for me, this the Pacific Carriers case sort of leapt out as being similar to some of these facts.
Yep. Alrighty, I'll make a note of that. We'll revisit that for sure. Yep. Cool. Anything else? So in terms of, we'll pick up a couple of other little details as we go through. But in terms of thinking about, okay, Bob is in this position where he's been caught high and dry building this yacht, and he's about to get no money. What is best case scenario for Bob in this set of
To
circumstances?
hold out Netbank.
So to
pursue them or stop them from not paying him would be my first avenue. And then if that fails, you could hold Janine liable.
Brilliant. Okay, yeah. So we're thinking about Bob's best option is to go after the bank in best case scenario, and then if that fails, sort of follow up by chasing Janine personally. And so we'll use that as the sort of frame for our answer to think about, here's the best thing for Bob and the thing that we'll be hoping for the most. But if that doesn't work out, we've also got this backup plan that we'll be able to pursue as well. So let's think firstly about Bob pursuing the bank. What do we need to prove, basically, in order for that to be successful?
That Janine's an agent acting in apparent authority on behalf of Netbank, the principal.
Fantastic. And so in thinking about sort of crafting, answers to hypothetical problems, and in terms of your assessment letters of advice, it's obviously framed a little bit differently when it's a letter of advice framed, sort of targeted to the client themselves. But the same principle, having a really clear, one sentence of here's the objective and here's how we're going to get it. So, we want to enforce the contract against Netbank by arguing that Janine was an agent for the bank acting with apparent authority. Really clear, here's what we're going to try and do, and then you flesh that out by explaining how you go through all those steps. But a really nice, simple, objective statement is a really good way of consolidating your advice or your answer, not only to your reader or me as the marker at the sort of the end product, but it's also really helpful for you in constructing the answer, because it gives you a sort of a touchstone to keep coming back to. Right, every sentence that follows this in the next couple of paragraphs or however long needs to be in service of this aim, and that will help you really pull together a tightly honed argument or answer. So here we're trying to argue that Netbank held out Janine. She acted with apparent authority to enter into this contract with Bob. So the next thing then is to, I suppose, think about that agency relationship in a bit more detail. And what's the most relevant thing to be thinking about in terms of the agency relationship? How do we know what that relationship is going to be based on, and then set out what the agent can and can't do and things like that?
Looking at the duties of the agent.
Yep. And how do we know what those duties are?
Would it go back to what I was saying before about the employee-employer relationship? Like what is within the scope of her role?
Yeah. So thinking about the broad principle being that the agency relationship being determined by the substance of the agreement between principal and agent. In this case, we obviously don't really know what that is. If we could find that out, that would be great. But we have a sort of sub-principle within the broad idea that employees will be agents of their employer if they act within the scope of their employment. So that's a good starting point for us as well, is to say, look, there's an employer-employee relationship going on. That will at least start to drive some of what's going on here. Does that make sense? Cool. What would you do next? So we've got our clear statement of what we're trying to do, where we've said a bit about the agency relationship and mentioned the employer-employee thing as being relevant. Where do you think you'd take things next?
Well, acting on behalf of Bob, I'd want to actually argue that she was acting within the scope of her job and that she was fulfilling her role in commissioning Bob to do the job. I'd obviously want to go that way first before I potentially flip it.
Yep. So thinking about best case scenario, the sort of not necessarily the fewest hurdles because it relies on some pretty big leaps, but the straightest course is to argue that it's that Janine was acting within the scope of her employment, and therefore the bank will be bound by her actions. Yeah, absolutely. So you could mention that, you could discuss that, you'd weigh how likely that is or not, and make reference to some gaps in the facts where we need to find things out. Let's say that wouldn't get up because it seems like a bit of a leap. What would be the next line of argument that we'd be looking at? We've talked about it a few times now.
Her job is to, as a manager, you would propose, is only to give loans, not to commission yachts.
Yep.
So that would be where I'd flip it. Like, that Netbank would argue that that's outside of the scope of her job, that this is not something that is, what she's been given permission to do or within her authority to do.
Mm-hmm. Yep. So pretty clear, and, based on the facts, and even if we had more facts, it may not change it. Pretty compelling argument that Janine isn't acting with actual authority in this instance, that she is outside the scope of her employment. So then we'd be thinking about apparent authority, right? So we've sort of talked about this a few times, but now really focusing on it. What are some of the broader principles or ideas at play when we talk about apparent authority?
The third party is going to rely on the representations by the contracting party.
Yep, absolutely. So it hinges on what's being represented to the third party. So, coming back to this idea that it's the authority as it appears to others as being really important. Yep.
And that they're not, or they're unaware that they're not able to contract. So based on the information that's provided by Janine that she is supposed to, and the yacht builder is none the wiser.
Yep. So thinking about what information Bob has been given, and whether there's anything that should alert him otherwise or not. Yep. Another thing that would be important to mention kind of, fairly early on in discussion of apparent authority is that it arises independently of the actual authority of the agent. So the actual authority, which we've established probably doesn't exist, doesn't actually matter anymore. It's completely on what the apparent authority would be. And that's worth mentioning just because we know that a key argument of Nitbank is going to be that there's no actual authority. So it's worth just including that sentence to just say it doesn't actually matter whether Nitbank argues that or not, or, succeeds in that argument or not. The apparent authority doesn't matter what the actual authority is, as long as there's that appearance to others that this authority exists. So then, you could have the discussion and kind of weigh the arguments about, what Janine's been held out as a manager for a business loan, and has then just sort of said, oh, well, why don't you build us a yacht while you're at it? You could go through the arguments that Bob would make in terms of she's been held out as the manager, she's got this apparent authority. You could then go through the arguments of Nitbank, sort of saying, look, banks tend not to commission yachts. And, the fact that he's come in for a business loan and this person who has been held out as a manager, in fairness, but may or may not be a manager, has gone off the rails and started talking about, I reckon we could do with a boat, should have kind of alerted Bob to the fact that there is sort of something amiss, that, it should have alerted Bob to this idea that Janine's sort of stretching a bit. She's not doing what you would expect a bank manager to do. And you'd reasonably expect that there should have been a few alarm bells going off in Bob's mind to go, maybe I should actually look into this a bit more before I go and build a whole boat.
It's COVID, slim pickings for business.
Yeah. Well, so my sort of follow-up question was going to be, there's those two sort of sets of arguments. You've got Bob's kind of initial, narrative. You've got the kinds of things that Nitbank is probably going to come back with. What is there anything that Bob could say to kind of counter those arguments from Nitbank that, Janine just sort of talking off the bat about building a yacht should have, signaled to him that something wasn't quite right? Can he counter that argument at all?
Is that where my reference to Pacific Carriers would help?
Yeah. So did you want to talk about that?
Well, that was about a bank employee. I'm just reading my notes here, sorry.
No.
That was about an official rubber stamp from the bank, which gave the impression that she had great authority to be able to contract. So that the fact that she's a manager, that she's presented herself and been able to go through with that. The court held that when an agent is acting honestly, exceeded their authority and stamped a contract of indemnity, the principal was liable to the third party for the contract made by the agent. So because she was acting on that apparent authority, I would be using that particular case to counter or to help my argument.
Yep. Awesome. So, it's making the argument that, it's not just that the bank has kind of held her out to say, oh yeah, you want to talk about business loans, here's Janine, the manager. It's gone beyond that, and she's actually done something to create the impression that she's got the authority to make this contract, right? The fact that she's initiated the conversation would probably itself be a fairly persuasive factor. You wouldn't, even if you would sort of think, oh, banks don't really commission boats, that's kind of weird. You wouldn't expect someone to initiate that conversation if they didn't have the authority to follow through with it. And so Bob might be able to rely on that as saying, it's not just that the bank has held her out as having authority. Her actions have actually created this impression that she's got the authority to follow through with this contract as well.
I think like what I noted as well, I mean, it's not specifically in the facts, but the fact that she's been quite honest about going about it as well sort of stamps back to that Pacific Carriers. She's not sort of in the fact, she hasn't armed and armed. She's been quite clear and concise that this is what she wants Bob to do, which would enhance that impression that she has the authority.
Yeah. And she's got a fairly plausible-ish argument around the reasoning about they can entertain customers on there, or probably really what they're using it for is sort of more corporate events you might expect. So there's at least some kind of logic. If you dug too deeply, it might fall a bit apart, but there's at least some logic to the reasons why a bank might want to own a yacht as part of, a broader business engagement activity or something like that. So, there's, even though Knitbank is going to be arguing, look, banks don't own boats, why would you think that this would be okay? There's enough in the facts. Janine's held herself out as being able to do this. She's initiated the conversation. She's kind of explained her reasoning in terms of, oh yeah, I think we could really do something that'd be really great for us. Can you go ahead and do this? There's enough in there that we can at least make a pretty reasonable argument that she does have this apparent authority to make this contract with Bob, and therefore, keep. There would be a strong argument to get the bank to follow through with it. So you'd probably be worthwhile including a line about apparent authority being a question of fact and therefore ultimately determined by the court, but referring back to these persuasive arguments that you've made, there's a reasonable likelihood that the court would find in Bob's favor, and that those arguments and interpretations of the facts would prevail. If Bob is successful in that argument, I think it was Tammy mentioned it before, would be chasing an estoppel in equity against Knitbank to prevent them from withdrawing from the contract. If we can make the argument successfully, the rest kind of falls into place quite neatly. Does that make sense? So we can then sort of move on to talk about enforcement against Janine as a plan B. But before we do that, were there any questions about sort of the plan A enforcement against the bank? Any questions about apparent authority? Awesome. Alrighty, let's move on then and sort of talk about enforcement against Janine, because that is a really useful backup as well. There are some pretty hefty limitations which we'll talk about, but why would we have a claim against Janine if we're not successful against Knitbank?
Is that to do with a breach of her implied warranty?
Yep. So do you want to talk about that a little bit more or elaborate?
I've really only just noted it.
Okay.
Isn't that where the representations, or the third party relies on those representations that are made?
Yep. Yeah. So it's because
so during
Bob,
the discussions, between Bob and her. He's relied on whatever she is saying to him to be, part of the authority that she has.
Yeah, so it's if in this contract, if Janine doesn't have apparent authority, there's nevertheless an implied warranty that Janine did have authority, and in not having that authority, Janine has breached that implied warranty, and therefore Bob would be able to bring an action against Janine.
Is that deemed like, because of that breach of warranty, is that deemed basically a misrepresentation? So because she didn't have the authority to act, it's clearly a misrepresentation?
Yeah.
Okay.
There's the other thing that we need to think about in terms of running against Janine is the broad principle that an agent is not liable where they disclose the name of the principal. And that's a broader principle, PLE, not PAL, broader principle of the agency relationship is that where you know who the principal is, the agent isn't liable. The exception to that is that where the agent is acting outside their authority, that general rule doesn't apply and the agent does become liable. I've just noticed.
Under the misrepresentations, isn't the principal still vicariously liable as well?
So the difficult thing here is that if Janine has acted outside even her apparent authority, then it's the principal is no longer liable and the liability falls onto the agent. If Janine had acted outside her express or actual authority, but within the apparent authority, then the principal still could be vicariously liable. But because if we're going against Janine,
we should all sing the song.
You froze there, Jacob.
Sorry, yeah, I'm just getting the notification that it's been a bit unstable. So it's the liability for the vicarious liability can apply in negligence, but we're then going on to yet another kind of another set of kind of hurdles to argue that Janine was negligent in what she did, which could be tricky. The other thing that's makes it a little bit difficult is that, or that makes it easier to run against Janine is that if the authority was express, it would be really much clearer to argue that the principal was vicariously liable. But arguing that, or if we're assuming that Janine's apparent authority wasn't even present, if there wasn't apparent authority, holding the bank vicariously liable for that breach as well just becomes a lot more difficult. So in terms of pulling together, this answer, if we're assuming that there's no apparent authority and therefore we can't pursue the bank under apparent authority, holding the bank vicariously liable as well is going to be a bit more tricky. And so if we're thinking about Janine as having breached that implied authority, it also makes sense to pursue Janine personally for that breach of the implied warranty. Does that make sense? I'm sort of, conscious that there were a few drop-ins and outs for that one. But yeah, you could, but if we're sort of assuming that at this point we haven't been successful against the bank because there's no apparent authority, it becomes quite difficult to hold them vicariously liable as well. You may as well just kind of go all in on Janine at that point.
At that point, though,
yeah,
it would be very difficult. Well, I would have thought, she's a bank manager. She's not going to have the kind of dosh to hand over in damages for a yacht.
Yep. And that's the sort of the final point to this answer is to say, you know, he fairly safely has an action against Janine. It's a pretty solid argument. But yeah, in practical terms, is he going to be able to recover enough for a boat? Probably not. And that's why we would very much view action against Janine as a plan B, because it's legally the safer or more solid argument. There's less in doubt that we would have an action against Janine, but financially there's, you know, less reward for pursuing that pathway. So you'd kind of, in structuring your answer, and especially in terms of actually advising the client, you would very much frame it as, look, we would want to go after the bank because that's the best chance of getting the full money back. But there is some uncertainty around whether we would succeed in that or not. Therefore, we've got Janine as this useful backup. The legal argument is more solid, but you know, the odds of recovering the full amount probably pretty slim. But it might be a means of getting something rather than nothing, and that's why, yeah, you'd keep it in your back pocket as the plan B argument. Does that make sense? And it would be important to, you know, frame the advice in those terms, to be quite clear that, you know, there is a gap between the best option financially and the best option in terms of what is most likely to succeed based on the facts, and you know, giving all that information to the client so that they can make an informed decision about how they would like to proceed, basically.
Would you, in a letter of advice about this, would you note that success in either avenues is not going to give him necessarily the total cost of the yacht? Like, would you make that clear to the client, or is that something that you just leave for the client to devise for themselves?
You'd be very clear. I mean, I suppose there's two parts to this answer. The first part being from the perspective of assessment in this course and writing a letter of advice. I wouldn't be expecting you to go into the detail of, you know, when you go to court, there's no guarantee of anything. You know, there's costs, there's costs of the other side if you lose, all those sorts of risks. I'm not expecting any of that kind of detail in the assessment answers, but yeah, absolutely. You know, in terms of actual practice, being very clear with the client about what, especially with litigation, you know, up to litigation where it is just, you know, back and forward between lawyers, maybe looking at mediation or something. It is a bit more less necessary, I suppose. Still important, but certainly before commencing litigation, it is really important to be upfront with clients about, you know, even if the argument is really solid, there are no guarantees. You know, you can win in court, you can get the court order, and that still might not be enough. Then you have to go through, you know, summary judgments, debt collections, all that sort of stuff. So, you know, and that's a level of detail that's way beyond this course. and certainly way beyond a 600 word count for your assessment. But yeah, absolutely in practice, being quite clear about the risks and associated rewards is good practice for sure. Any other questions about that hypothetical problem? Awesome. Well, I had left that time for questions about the assignment, and then there were none. So we've ended up a couple minutes early. I'm just trying to think if there is anything that I should say about the assignment that I didn't say last week.
I think you
Can we
made
go-
it pretty
can they call
clear.
I thought so, but I was also conscious that there was some things that I didn't want to say without you having the question already in front of you. So I'm just trying to think if there's anything that I need to add.
I think you've made it really clear. I actually think this is probably one of the clearer assessments I've had in a while.
Yeah, I have to agree.
It's
That's
pretty,
good. That's good.
Pretty clear and concise. I don't, if there's, as you said earlier in the course, you don't put red herrings in because there's no point. It's pretty clear.
Good. Okay. Well, in that case, we might have a bit of an early mark. So there's no class next week. It's the break. Then we come back in. Well, then you've got your assessment due on next Friday. I mark there's not a horrendous number of them, so I mark them, over the next few days, and then I get those back to you, hopefully by the Wednesday, if not the Thursday morning. And then, so quick turnaround. Then on next Thursday, so Thursday after, week 6 Thursday, our tutorial discussion is a little bit of a debrief of the assignment. So talking through, things that worked, things that didn't work from, I suppose, my perspective, marking and sort of generalizing common themes about what was really done really well, what we can improve for the second assessment, but then also opening that discussion up to think about, what strategies you used, what the way that you approached the assignment, the way that you approached studying for the assessment, those sorts of things, sharing some of that so that everyone can kind of go into the second assessment, which, the second assessment ramps the difficulty up a little bit more. So having going into that harder assessment with a bit more sort of a few more tools in your tool belt. So, that's what's coming over the next couple of weeks. But in the meantime, good luck with the...
Sorry, just to butt in.
Yeah, of
On
course.
that note, if there are people, not myself, but others that do apply for an extension because of extenuating circumstances, is that discussion obviously going to be on hold?
So the week 6 discussion doesn't get recorded. And I sort of do a bit of a summary, dot point summary after the fact for people who aren't able to attend, but I don't release that discussion until after all the extensions have come in. If there are lengthy extensions, there's a separate assessment that, like not a supplementary assessment, but the idea is that it's a different assessment, so it doesn't hold up the release of everyone else's marks. So extensions, things happen, and I haven't had any yet, but if there are extensions, we deal with that. And if it is going to hold things over too long, there's an alternate assessment that gets used instead. Cool. So yeah, so in the meantime, best of luck with that assessment. If you do have questions or concerns over the next week or so, feel free to get in touch. Yeah, excellent. Alrighty, thanks everyone for coming along, and we'll see you in a couple of weeks' time. Good evening.